the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome back to the Think Tank. So we've pretty much got my new setup set up. It's going to be a little bit bumpy because I've got a couple of different screens going and trying to figure all that stuff out. Oh, good day, Dingo. Good to see you. Thanks very much, Mixie. Thank you very, very much. So I am going to start. This is the video from Sandra Birchmore's apartment. This is Sandra going inside, and about 4 hours later, we will see Matthew Farwell come in. So let's watch this together. She's in and out of the door here, shoveling off, I do believe, shoveling off her vehicle. Good morning, Ruthie. Hello, Mexie. So she comes back in after cleaning off her vehicle. And about 4 hours later, look at this guy. Not too suspicious at all. So this is Officer Matthew Farwell, and there he goes. He's admitted to being there, saying he had just broke it off with Sandra. So a report issued by an independent pathologist on the death of Sandra Birchmore has left Stoughton Police Chief profoundly disturbed and troubled. A 2022 internal investigation by the Stoughton Police Department found that 3 of its officers engaged in inappropriate relations with Birchmore. The officers allegedly met her when she was 13 years old as a part of the Stoughton Police Explorers program. All 3, William Farwell, which is Matthew's brother, and former Stoughton Deputy Chief Richard Devine, they've all left the department at this time. Birchmore, 23, was found deceased in her Canton apartment in 2021. She was pregnant at the time, and at the time, it was considered a SUI by the chief medical examiner, and he was saying that there was no foul play. Well, Dr. Bodden came in and blew that out of the water, didn't he? Michael Bodden. In her statement, Chief Donna McNamara said, "While I am not a trained medical examiner and I am not qualified to draw my own direct conclusions, the findings certainly warrant further examination at the highest level." How sad is that? So this is Darlene Smith versus Matthew Farwell. So Darlene Smith is Sandra Birchmore's aunt. Sandra went through a bunch of losses, her parents, her grandmother, and really was left on her own. And of course, these monsters know how to prey on people that are needy. Let me see, needing some support. So, findings, rulings, and order imposing sanction. This decision and order addresses 2 disturbing developments that are adversely affecting the practice of law in this Commonwealth and beyond. So, a little bit of information. Sandra was living in Canton when she was found. So we've got similar attorneys, we've got similar a lot of things, which is basically Karen Reed's trial opened up the door for Sandra's case to be looked at that much closer. Oh, Lordy. This decision and order addressing two disturbing developments that are adversely affecting the practice of law in this Commonwealth and beyond. The first is the emerging tendency of increasingly popular generative artificial intelligence, AI systems, such as ChatGPT and Google Bard, to fabricate and supply false or misleading information. The second is the tendency of some attorneys and law firms to utilize AI in the preparation of motions, pleadings, memoranda, and other court papers, then blindly file their resulting work product in court without first checking to see if it incorporates false or misleading information. Unfortunately, both tendencies have surfaced in this case. Specifically, the court is the unhappy recipient of several large legal memoranda filed by counsel for plaintiff Darlene Smith that cite and rely in part upon wholly fictitious case law in opposing the motions to dismiss filed by William Farwell, Robert Devine, and Joshua Heel of the town of Stoughton, collectively the defendants. Yeah, they're all married. And 3 cops admitting, yes, dingo. 3 cops admitting having relations with this minor, starting anywhere from the age of 13 to 15. December 7th, 2023, the court conducted a hearing for the purpose of better understanding how the fictitious case citations came about and to decide what, if any, sanction to impose on plaintiff's counsel for submitting false and misleading information to the court. Having considered all the facts and circumstances and hoping to deter similar transgressions by plaintiff's counsel and other attorneys in the future, the court will require plaintiff's counsel to pay a monetary sanction in the amount of $2,000. Factual findings. This case arises from the tragic death of 23-year-old Sandra Birchmore by a parent sui in February of 2021. Plaintiff Darlene Smith is Sandra Birchmore's aunt and the personal representative of Sandra Birchmore's estate. Ms. Smith commenced this wrongful death action against defendants Matthew Farwell, William Farwell, his twin brother, and Robert Devine and Joshua Heel, and the town of Sutton in December of 2022. Defendant M. Farwell, W. Farwell, and Devine are former Stoughton police officers. Defendant Heel is the former animal control officer for the town. The gist of the plaintiff's claims is the defendant took unlawful advantage of Sandra Birchmore by engaging in relations with her, beginning in some instances, at least when she was under 16 years of age. In particular, plaintiff asserts that M. Farwell, W. Farwell, and Devine cooperatively groomed SB from an early age for their shared exploitation. Heel is alleged to have had consensual relations with Sandra when she was an adult, knowing she was involved in an ongoing relationship with M. Farwell, W. Farwell, and Devine. The town is a defendant because it hired and employed the individual defendants, some of whom allegedly had relations with Sandra while they were on duty. Can you imagine? Not only were they doing this stuff, but they were also doing this while they were on the clock. They were asking her to show up at certain places. They were asking her to call at certain times. They were asking her to buzz them up when they got there. All of these men were in a place of authority. This young girl needed some form of, what am I looking for? A male that she could trust and help guide her. Some people to help her form connections with other kids, possibly when she's older to also be a police officer. But what they chose to do instead was start taking advantage of her. 13 to 15 years old. They met her when she was 13. And they're saying that these relations started when she was 15. All in places of authority. Defendants W. Farwell, Devine, Heel, and the town responded to the plaintiff's amended complaint by filing separate motions to dismiss. Plaintiff counsel, in turn, submitted 4 separate memoranda of law in opposition to the motions to dismiss, collectively the opposition. Each of the opposition is signed by plaintiff's counsel in accordance with Mass, and it gives us the code. Upon reviewing the opposition, the court noted that plaintiff's counsel legal citations concerning the elements of wrongful death action in 2 of the oppositions seemed amiss. The relevant section for the opposition states as follows. To establish a wrongful death claim, the plaintiff must prove the following. 1, the defendant owed a duty of care to the deceased person. 2, the defendant's acts or omissions fell short of what a reasonable person would have done under similar circumstances. 3, the defendant's breach of duty was the cause of the deceased person's death. 4, the death of the deceased person resulted in damages. Plaintiff's opposition to Heel motion to dismiss. At 6, plaintiff's opposition to Devine's motion to dismiss. At 5, the court spent several hours investigating the case law cited by plaintiff's counsel, but ultimately was unable to locate Bartlett versus Gray. On November 1st, 2023, all counsel appeared in person before the court for oral argument on the motions to dismiss filed by defendants W. Farwell, Devine, Heel, and the town. Before turning to the substance of the parties' motions, the court informed plaintiff's counsel of its discovery of the 3 fictitious case citations, an inquiry how they would come to be included in the plaintiff's opposition. Plaintiff's counsel stated that he was familiar with the fictitious case citations and that he had no idea where or how they were obtained. When asked who had drafted the opposition, plaintiff's counsel responded that they had been prepared by interns at his law office. The court thereupon directed plaintiff's counsel to file a written explanation of the origin of the fictitious case citations on or before November 8th, 2023. So they're basically trying to say that her aunt is putting together a fictitious case to wrongfully convict these guys. On November 6, 2023, plaintiff's counsel submitted a letter to the court in which he acknowledged the opposition inadvertently included citations to multiple cases that do not exist in reality. He attributed the bogus citations to an unidentified AI system that someone in his law office had used to locate relevant legal authorities to support our arguments. At the same time, plaintiff's counsel apologized to the court for the fake citations and expressed his regret for failing to exercise due diligence in verifying the authenticity of all case laws referenced provided by the AI system. He represented that he recently had subscribed to Lexis, which he now uses exclusively to obtain cases to support our arguments. He also filed amended versions of the opposition that removed the fictitious case citations. Hello, James. Good to see you. Following plaintiff's counsel admission of fault, the court scheduled a hearing to learn more about the origin of the fictitious case citations to determine what, if any, sanctions it should impose as a consequence of plaintiff's counsel potentially misleading submission. The court also conducted a further, more searching review on plaintiff's motion papers, which confirmed that the fictitious case citations appeared in two of the plaintiff's oppositions, and disclosed that an additional non-existing case is cited in 3 of the plaintiff's oppositions. See Heel opposition, Devine opposition, and plaintiff opposition to William Farwell's motion to dismiss at 13. The court conducted the scheduled sanctions hearing on December 7, 2023. The plaintiff's counsel began the hearing by apologizing again to the court and by representing that the fictitious case citations were not submitted with the intention to mislead the court. He explained that the oppositions had been drafted by 3 legal personnel in his office, 2 recent law school graduates who had not yet passed the bar, and 1 associate attorney. The associate attorney admitted when asked that she had utilized the AI system. The plaintiff's counsel did not know which one. Plaintiff's counsel is unfamiliar with AI system and unaware before the oppositions were filed that AI systems can generate false or misleading information. He's also was unaware that his associate had used an AI system in drafting court papers, in this case until the fictitious case citations came to light. Plaintiff's counsel said that he had reviewed the oppositions before they were filed for style, grammar, and flow, but did not for accuracy of the case citations. He also did not know whether anyone else in his office had reviewed the case citations in oppositions for accuracy before the oppositions were filed. Plaintiff's counsel attributed his own failure to review the case citations to the trust that he placed on the work product of his associate, which, to his knowledge at least, had not shown any problem in the past. Yeah. What? Hola. Yeah. The court finds plaintiff's counsel factual recitation concerning the origin of the fictitious case citations to be truthful and accurate. The court also accepts as true plaintiff's counsel representation that the fictitious case citations were not submitted knowingly with intention of misleading the court. Finally, the court credits the sincerity of the Contrition expressed by plaintiff's counsel. These facts, however, do not exonerate plaintiff's counsel of all fault, nor do they obviate the next for the court to take responsive actions to ensure that the problem encountered in this case does not occur again in the future. Yeah, that's fair. That's fair. So, discussion. Many harms flow from the submission of fake opinions. With this admonition in mind, the court concludes that notwithstanding plaintiff's counsel, candor, and admission of fault, the imposition of sanctions is warranted in the present circumstances because plaintiff's counsel failed to take basic, necessary precautions that likely would have averted the submission of the fictitious case citations. Oh, lordy, lordy. Lordy, lordy. His failure in this regard is categorically unacceptable. In the explanation of its decision that follows, the court will briefly address the benefits and dangers that AI poses for our legal system. Potentially instructive cases involving the misuse of AI from other jurisdictions and the specific basis of rationale for the sanction imposes upon bailiffs. Plaintiff's counsel in this case. Oh, lordy. What? Don't be bringing AI into this. Don't you be bringing AI into this. The term artificial intelligence, or AI, first was coined by scientists in the 1950s to encompass the capability of computer systems and algorithms to imitate intelligent human behavior. Artificial intelligence, via the Merriam-Webster dictionary, generative AI represents the latest wave of AI technology. Functionality, generative AI can create text, images, sound, video, or other content in response to users' prompts. That's scary, you guys. Yeah. Like, how are these cases going to be figured out when there's all of this shite going on around the back end? Lordy, lordy. For the legal profession, generative AI technology offers the promise of increased efficiency through the performance of time-consuming tasks using just a few keystrokes. For example, generative AI can draft simple legal documents such as contracts, motions, and emails in a matter of seconds. It can provide feedback on already drafted documents. It can check citations to authority. It can respond to complex legal research questions. It can analyze thousands of pages of documents to identify trends, calculate estimate settlement amounts, and even determine the likelihood of success at trial. Who knew? AI and the practice of law. How lawyers can take advantage of Chat GPT and other large language models disrupting the legal industry. Given its myriad of potential uses, generative AI technology seems like a superhuman legal support tool. The use of AI technology, however, also poses serious ethical risks for the legal practitioner. For example, entering confidential client information into an AI system potentially violates an attorney's obligation to maintain client confidence because the information can become part of the AI system's database, then disclosed by AI system when it responds to other users' inquiries. Wow. It's getting scary out there. It's getting scary. Additionally, as demonstrated in this case, AI possesses an unfortunate and unpredictable proclivity to hallucinate. The New York Times, the terms hallucinate or hallucination, as used in the AI context, are polite references to AI habit of simply making stuff up. AI hallucinations are false or completely imaginary information generated by an AI system in response to user inquiries. AI researchers are unsure how often these technological hallucinations occur, but current estimates are that they happen anywhere from 3 to 27% of the time, depending on particular AI systems. Generative AI hallucinations can be highly deceptive and difficult to discern. The fictitious information often has all the hallmarks of truthful data and only can be discovered as false through careful scrutiny. For example, demonstrated in this case, AI can generate citations to totally fabricated court decisions bearing seemingly real party names with seemingly real reporter volume and page references and seemingly real dates of decision. Attorneys submit false case law to federal district court through misuse of AI. In some instances, AI even has falsely identified real individuals as accused parties in lawsuits of fictitious scandals. What? Oh, like what the hell is going on? You guys. This is not a positive thing. So Australian mayor threatens to sue OpenAI for defamation by chatbot and Gizmodo. System reportedly falsely names Australian mayor as a convicted criminal in a bribery scandal at an Australian bank. Verma Ormus ChatGPT invented a harassment scandal that named a real law professor as the accused. The Washington Post, AI system falsely alleges, citing hallucinated Washington Post article, that law professor was accused of misconduct. For these reasons, any information supplied by a generative AI system must be verified before it can be trusted. Well, it sounds like it. If you can put in the information and it just listens to you, that's basically what I'm understanding. Oh, it is so wild, James. Oh, Lordy. While determining what sanction is appropriate for an attorney's inclusion of false AI-generated information in pleadings or motion papers appears to present a novel issue for Massachusetts courts. This is not the first time a judge has levied sanctions against a lawyer for the misuse of AI. Are they talking about Lolly? Perhaps the most widely publicized incident involves United States Federal District Judge P. Kevin Castell's recent decision sanctioning plaintiffs. The facts of Mata are similar, but admittedly not identical to those of this case. In Mata, the plaintiff's attorney filed a sworn affirmation that was prepared in part through the use of generative AI. The affirmation contained numerous citations to fictitious cases, including a citation to a non-existent case purportedly decided by the 11th Circuit. Counsel for the defendant subsequently notified the court that she was unable to locate most of the case law cited. Okay. A few cases which defense counsel has been able to locate do not stand for the propositions for which they are cited. The plaintiff's attorneys nonetheless did not withdraw the affirmation or offer the court any explanation how it could possibly be the case purportedly in the Federal Reporter or Federal Supplement could not be found. When the court was also unable to locate the elusive cases on its own, it ordered the plaintiff's attorneys to file an affidavit that included an appendix containing copies of 8 suspect cases in their entirety. After several delays, the plaintiff's attorney filed the requested affidavit accompanied by excerpts from 7 of the 8 cases. They explained that the excerpts may not be inclusive of the entire opinions, but only what is made available by online databases. They also reported that they had been unable to locate one of the 8 cases. The court reviewed the case excerpts submitted by the plaintiff's attorney, and although they admittedly bore some traits that are superficially consistent with actual judicial decisions, the court quickly concluded that all the excerpts and all of the cases from which allegedly were obtained were fake. Jesus. The plaintiff's attorneys eventually acknowledged that they obtained each of the phony case citations, quotes, and excerpts from ChatGPT, a generative AI system that is accessible for free on the internet. Additional information supplied by the plaintiff's attorney further established that they had continued to advocate for the fake cases and legal arguments contained in the affirmation after the reason to believe that the citations were false. Justice Castell ruled that actions of the plaintiff's attorneys in submitting the continued to defend the fictitious cases they had submitted to the court in the affirmation constituted sanctionable conduct under, and it gives the sanction. In deciding to impose sanctions, Justice Castell found the plaintiff's attorneys' misbehavior went well beyond poor and sloppy research and amounted to bad faith. Oh, Lordy. For these reasons, Judge Castell ordered the plaintiff's attorneys to promptly undertake each of the following corrective steps. Mail a letter to their client containing a copy of the court's sanctions decisions with hearing transcripts and exhibits. 2, mail a similar letter to each of the falsely cited federal judges. 3, file copy of these letters sent to the judges and their clients with the court. Judge Castell also imposed a monetary sanction of $5,000 on the plaintiff's attorneys payable to the court. Why are they bringing this kind of shite into another case? While the Mata case offers a particularly vivid example of the many harms that can flow from careless and unchecked use of AI technology in the preparation of court papers, it is not alone. There's been at least 2 other reported decisions in the United States over the past year in which courts have been confronted with and called upon to address false and misleading information contained in court submissions that were created with the assistance of AI technology. Wow. So, referring plaintiff's appellate attorney for possible disciplinary actions based upon its submission of reply brief and contain non-existent authority generated by ChatGPT, announcing the court's intention to sanction moving parties' attorneys for submitting reply papers containing fictional and or erroneous citations as a result of his reliance on a website that contained information created by generative artificial intelligence. Other similar decisions undoubtedly exist or are in the works. A Colorado lawyer was suspended for using AI platform to draft legal motions. Lordy, lordy, all this fudgery going on. Ordering defense counsel to show cause in writing why he should not be sanctioned for citing non-existent cases to the court. The basis of rationale for the sanction imposed in this case. The court recognizes that the factual circumstances of this case differ in material ways from those presented in MATA. Although both cases involve the submission of multiple false and misleading case citations to the court, plaintiff's counsel in this case have been far more forthright in admitting its mistakes and has not demonstrated any of the compounding deception exhibited by the plaintiff's attorney in MATA. But plaintiff's counsel lapses still are sanctionable because they resulted from this lack of diligence and apparent failure to take seriously the responsibility of conducting litigation in compliance with the rules of a civil procedure. Oh, Lordy. Rule 11 of the Massachusetts Rules of Civil Procedure imposes an obligation on attorneys in this Commonwealth to ensure that sham pleadings are not employed, and the pleading is based upon reasonable inquiry and an absence of bad faith. Plaintiff's counsel, knowing failure to review the case citations in oppositions for accuracy, or at least ensure that someone else in his office did before the oppositions were filed with this court, violated his duty under Rule 11 to undertake a reasonable inquiry. Simply stated, no inquiry is not a reasonable inquiry. For these reasons, the court, in all its discretion, will require plaintiff's counsel to pay $2,000 to the clerk of courts as a sanction for his violations. Oh, Lordy. One further word is in order. Regardless of what others may believe, the court considers the sanction imposed upon plaintiff's counsel is in this instant to be mild given the seriousness of the violation that occurred. Making false statements to a court can, in appropriate circumstances, be grounds for disbarment or worse. 1 year suspension, appropriate where attorneys plead guilty to one count of making false statements. Disbarment, appropriate where attorneys knowingly lied under oath and perpetrated lies through making false statements in disciplinary proceedings. The restrained sanction imposes here reflects the court's acceptance and previously noted of plaintiff's counsel representation that he generally is unfamiliar with AI technology and that he had no knowledge that an AI system had been in use in the preparation of the oppositions, and that the fictitious case citations were included with the oppositions in error and not with intention of deceiving the court. There is, however, a broader lesson to be learned here. It is imperative that all attorneys practicing in the courts of this Commonwealth understand that they are obligated under Massachusetts Rule Civil P11 and 7 to know whether AI technology is being used in the preparation of court papers that they plan to file in their cases, and if it is, to ensure the appropriate steps are being taken to verify the truthfulness and accuracy of any AI-generated content before the papers are submitted. Technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for the assistance, but existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. The blind acceptance of AI-generated content by attorneys undoubtedly will lead to another sanction hearing in the future, but a defense based on ignorance will be less credible and likely less successful, as the dangers associated with the use of generative AI systems become more widely known. For these reasons, it's hereby ordered that plaintiff's counsel pay the clerk of court the sum of $2,000 as a monetary sanction within 10 days of the date of this order. No other or further sanctions is imposed at this time. This was back in February of 2024. Yeah, what the hell? What the hell? Let's go over here.
Having an inappropriate relationship with a woman beginning when she was a teenager.
And police in Abington just placed an officer on leave, sources say, in connection with this case. WBZ's Beth.
So at this point, I'm learning that there is a possible fourth. Was there no audio? Let me see. Let me know if this is any better.
Police officers are accused of having an inappropriate relationship with a woman beginning when she was a teenager.
And police in Abington just placed an officer on leave, sources say, in connection with this case. WBZ's Beth Germano shows us how the Stoughton police chief is trying to keep those officers from ever working again.
I stand before you today as a civil servant who is heartbroken.
Stoughton Police Chief Donna McNamara vowing transparency as she details how
Police officers. Former Stoughton police officers are accused of having an inappropriate relationship with a woman beginning when she was a teenager.
And police in Abington just placed an officer on leave, sources say, in connection with this case. WBZ's Beth Germano shows us how the Stoughton police chief is trying to keep those officers from ever working again.
I stand before you today as a civil servant who is heartbroken.
Stoughton Police Chief Donna McNamara vowing transparency as she details how 3 officers are accused of abusing their positions of authority to carry out an inappropriate sexual relationship with a young woman for several years.
Through a sustained and deliberate combination of lies, deceit, and treachery.
The now former officers are William Farwell, pictured here, and his brother Matthew, who they say first met the young woman when she was 13 in a Police Explorers program. Also accused, former Deputy Chief Robert Devine, all allegedly preying upon a vulnerable teen who looked up to officers.
The admiration led her to form relationships with men who were willing to take advantage of her.
At age 27, investigators say Matthew Farwell began the relationship with a young woman who was then 15. Texts and explicit exchanges were shared while on duty. Investigators say when he broke off the relationship in February of 2021, when she was 23, she died days later, the medical examiner determining it was suicide and she was pregnant.
These men violated their oaths, and they are unfit to serve as police officers.
The district attorney says without victim testimony, charges are unlikely, saying in a statement, the investigation to date has not developed a prosecutable statutory rape case against any individual. But the chief makes clear what the investigation has developed.
The scope of this problem in our agency has been identified and pulled out by the roots.
The chief has moved to have the officers immediately decertified so they never serve in another department. In Stoughton, I'm Beth Germano, WBZ News.
Yeah, how sad. How very, very sad.
Case involving the Stoughton Police Department, investigators found 3 former officers had inappropriate relations with Sandra Birchmore. She's a young pregnant woman who died a few years ago. Her death ruled a suicide. But the Boston Globe is now reporting a prominent forensic pathologist hired by her family is now calling it a homicide. NBC 10's Mary Marco is joining us live from the Stoughton Police Department with more on what this report could mean for the Birchmore case. Mary.
So they have brought in Dr. Bodden. Now, if you know who he is or don't know who he is probably one of the most recognized coroners in all of North America. You listen when he talks.
Well, not only could this change the entire nature of the case, we are also learning that this was investigated under the same Massachusetts State Police unit as the Karen Reed case.
Now people are starting to see what we have been saying, that it was murder.
Melissa Mizzyberry runs social media pages seeking justice for the 23-year-old pregnant woman who was found dead in her apartment in February of 2021.
Basically, have been like trying to create a groundswell online to get people to realize that this young woman did not kill herself and her baby.
Sandra Birchmore's death was ruled a suicide, but a forensic pathologist hired by her family is now calling it a homicide, according to the Boston Globe. The family's attorney and Dr. Michael Baden's office declined to release that report to us.
Especially since a lot of people are putting eyes on the Karen Reed case, I am now able to piggyback off that.
Massachusetts State Police confirming it's the same unit but different officers as the Karen Reed case.
It's the same DA, it's the same Massachusetts State Police unit.
A 2022 investigation found 3 former Stoughton police officers had inappropriate relationships with Sandra after meeting her through the department's Youth Explorers program.
If there are more out there, hopefully they're going to start feeling safe to come out and say something.
Officer Matthew Farwell was 27 and Sandra 15 when the two began a physical relationship which lasted until days before her death.
I'm hoping that this will bring some justice to Sandra because she deserves justice, and so does the baby that she was carrying.
Now, those 3 Stoughton officers have denied any wrongdoing and could not be reached for comment. Live in Stoughton, Mary Marcos, NBC 10 Boston.
Yeah, can you imagine? Cannot be reached for comment. Unreal. Unreal. So what do you think, guys? What do you think? Yeah, Canton is, that entire area is very, very suspicious. They were going to have the same prosecutors, a lot of the same players in Sandra Birchmore's case as in Karen Reed's case. And we know what we learned about that area as far as Karen Reed went. So the fact that this has been happening possibly for since 2013, in around there when this Explorers program started up. The fact that Matthew Farwell was caught going into her apartment around the time that she stopped answering messages, taking any kind of calls, I think we know what happened. Are they going to actually be able to press charges on these people? I certainly hope so. I'd like to see this go to trial, and I'd like to see them all. At this point, they haven't even lost their ability to work for other stations, other police stations. That needs to be revoked. And they need to go to trial. She was a minor, and they took advantage of a situation, knowing that she did not have any kind of parental supervision. Most of her family had passed away. She's got her aunt now that is fighting for her and for her baby. Something else that was going on is Matthew, his wife, the day after Sandra passed away, his wife gave birth to a baby. While this was going on, Sandra was also asking Matthew to put his name on the birth certificate for her baby. And this was a problem for him. And somehow this argument got heated, allegedly, and he used his hands to make her stop breathing, and then propped her up and made it look like a suey. What do you guys think? When she first met Matthew Farwell, she was 13 years old. She was 13. They're saying that nothing happened in a physical way until she was 15. But what? That's still a minor. She is still a minor. He was 27. She was 15. She was fed to the wolves. So I'm going to continue doing my thing behind the scenes, going through more documents. I've got some more paperwork as far as Darlene Smith, her aunt, and Matthew Farwell go. I'm going to go through those documents and see if we can add anything to it. And if so, I will do another stream. I'm also in the process of figuring out how to run my dual monitors and hoping that my camera is in today. So if that's the case, we'll be able to see each other on stream again. So this is where I'm going to leave it, guys. Thank you very much for joining me. I appreciate it. And I appreciate you. Thank you, all my mods. You guys have no idea how much I appreciate everything you do for me. And with that said, guys, I'll talk to you soon in the next one. Bye.